presentation on drafting transactional legal documents. Before I introduce our speaker, who I'm so thrilled is here, I just wanted to go over a few housekeeping items. Jennifer has promised us a full program, so there may not be a lot of time for questions and answers afterwards. So if you have a question, we're going to ask that you please put it in the chat, and I will interject and ask Jennifer the questions as I receive them. So I will monitor the chat. This presentation is best viewed in speaker view, and all participants have been muted upon arrival, and we ask that you remain that way throughout the program. And again, we'll take any questions in the chat. So without further ado, I'd like to introduce our speaker today, Jennifer Chung. Jennifer is a Chief Legal Officer at AccuWeather, where she advises executives on all legal matters affecting the company and provides legal support across all lines of business and functions, including the areas of intellectual property, regulatory compliance, ad sales, emerging technologies, media, and data privacy. Before joining AccuWeather, Jennifer was the Assistant General Counsel for Meredith Corp., previously known as Time Inc., for 3.5 years. She managed a global trademark and domain name portfolios and assisted with other issues related to intellectual property and brand management in the print, digital, and social media ecosystems. Jennifer also served for the Honorable Robert M. Morgenthau as the Assistant District Attorney for the Manhattan District Attorney's Office. In addition, she was a law clerk to the Honorable Gabriel W. Gorenstein of the U.S. District Court of the Southern District of New York. Jennifer earned her JD with honors in 2001 and her certificate in cybersecurity and data privacy in 2019 at Albany Law School. She earned her bachelor's degree in chemistry and Asian studies in 1998 from Cornell University. And Jennifer is currently enrolled in a 17-month global MBA program. Please join me in welcoming Jennifer Chung.
Thank you, Joanne. So for some history, I've known Joanne since 2001 when she was in the career planning office, and over the last 20 years has been an absolute partner in helping me advance in my career. So thank you so much, Joanne, and thank you so much to Albany Law School for inviting me to participate in this event. So the topic today is drafting transactional legal documents. And I think my 20 years in the legal profession, has sort of shown me that there really is no one size fits all to this process. And I'm just gonna kind of give some highlights and tips based on my own experiences. Interest of full disclosure, I was a terrible law student and I did not do very well in my contracts theory class, but when it comes to drafting documents, I'm much better at it. But if there are questions along the way, please use the chat function and feel free to connect with me on LinkedIn, send me an email, whatever to follow up on this. And please download the AccuWeather app. It is fantastic. And onward, we will go. And so I think now the trick is, what are transactional legal documents? And really the easiest way to look at it is it's just documents that get deals done. So it's going to be contracts, agreements, even an invoice that you might have with Amazon, in theory, is a transactional legal document. Most of the time it will take place between two parties, and sometimes it's like with the government. If it's, let's say, an intellectual property registration filing, the timing of the anticipated relationship may impact the complexity of the document. So your Amazon invoice, super easy, you pay, it gets shipped, you get it, you're done, half a page. A treaty between countries might be thousands of pages. So you want to also be cognizant of the fact that just because you have a lot of pages in a document doesn't necessarily mean it speaks to the complexity of the relationship, but you want to be able to manage that concept as well. It also generally will involve a tangible or intangible property or right. I'm gonna guess that pretty much every single one of us has signed a lease document, a rental lease document at some point, which involves real property. Again, we've probably all traveled somewhere that had some kind of a ticket, and those are all things that could be potentially covered by a transactional legal document. And it's legally binding, right? Either by operation of law or regulation. And for those of us who live and operate, under common law principles, contract is going to be the bargain and the consideration that goes along with it. And the big picture goal here is you want to get the deal done as quickly as possible and to avoid disputes during and after. And now, again, I'm speaking very much from an American lawyer's perspective. I'm speaking from the perspective of someone who's in-house. And so my job is to make the company as much money as fast as possible. And so, part of that is going to be getting the deals closed, making sure the internal clients are happy, making sure the relationships are preserved, and making sure we don't have a problem on the back end. So just to level set where we are, because I think the participants on this webinar are going to have a very broad background. So you might have some litigators on the call, maybe some young lawyers, maybe non-lawyers. But just to kind of keep in mind that the types of transactional legal documents you may see in your lifetime will be like a real estate lease or a property sales agreement, tax filings, even a credit facility with a bank. Again, like even an airline ticket, investment agreement, there's all different ways these documents show up. And so a part of the conversation will always have to be, you know, trying to make sure the effort is commensurate with what you're trying to achieve on the back end. So for purposes of this conversation, we're going to talk super simple. Like, what does a simple contract life cycle look like? If you start at 12 o'clock, you're going to be negotiating the business terms. You're going to execute the contract and then celebrate because everyone's super happy the deal is done. The parties are going to be fulfilling their obligations. Maybe there's some issues that come along the way. Maybe there's some terms that weren't fully defined. You'll kind of deal with that internally. And then you'll have the end of a contract life. Either it naturally ends or terminates for some reason, and then you start all over again. So this is the framework I want to operate under. And obviously there are like tangents that come off of this, and it can be a little bit more complicated in certain instances. And I'm happy to field those questions. Now, when I draft a contract, these are the JC's thought process considerations. I think about what do I want, and I speak in I, but really I'm talking about the client, the customer, the stakeholder, whoever it is that's the decision maker here. And I think in terms of what do I want, when do I want it, what should I do, what must I do, what can I do, what could I do, what may I do, and then the flip sides, right? What shouldn't, mustn't, can't, couldn't do. How do I do this? How do I get paid? How do I get out of this? And probably the bulk of the contract will cover the what ifs. What if COVID? What if the parties hate each other? What if there's no money in the bank? What if the services stop? So all the what ifs are going to end up taking up the bulk of you know, what the document is. And you always think about, how does this end? It's been my experience that a lot of business partners will enter into contracts because they're super excited about the deal. Someone's going to get something, we're going to make money, everyone's really happy. And when, as legal counsel, we raise the possibility of the end of this relationship, everyone gets very agitated, right? Like, why would we be thinking about the end of the relationship? When really that's kind of what the document is about. You know, when everyone's happy and feeling good, you want to help each other and do whatever you want. But when things are bad, you go to the document, you go to the lawyers to find out what happened next. Big picture themes for consideration here. In general, you want to let the business teams negotiate the business terms. You let the legal teams negotiate the legal terms. Super broad strokes. This doesn't apply to everybody, but just kind of big picture. But you know, as legal counsel, I pay attention to the language of the negotiations to identify where the disputes might be, because I don't always know what the other party is like. I don't know what's important to them. I don't know what's going to be a trigger for them. So if the business teams come back and say, we can't settle on a price, that's a huge red flag up front. And you want to make sure then that if they do finally settle on a price, you've got terms in there that make it really clear how you got to that price, what's going to happen if there is a change in price, and what's going to happen if they don't want to pay because they don't believe the price is right. And so I will go back to the business teams and ask, oh, like, you know, what were the hot button issues while you're negotiating this deal? Because that will then give me a little bit more information on what terms I need to focus on. I focus a lot also on the end of the relationship, because it is often the case that when there is an issue, right, with a more complex deal, probably the person who drafted it, the person who was involved in negotiating it, is no longer at the institution or the organization, or they don't remember because it's been so long. I mean, I've been with AccuWeather now a little over 2 years. And now there are some deals I worked on a little over 2 years ago that are coming back to the table. I don't remember what happened. Like, I have to go back to my emails and my notes, right? But it's not on the top of my brain. So when someone says, why did we agree to this term? I have to go back to documents. And that's just me, right? What happens if you're in an institute, at an organization that's 100 years old and you're talking about an agreement that was signed in the 60s, right? Most likely the people who negotiate that deal are just not around. And so you want to think about, how do you draft these documents to preserve within the document some of the institutional knowledge that might be necessary later on? You know, who's going to be around to remember things? Maybe nobody. Another thing to consider is how do the parties get paid? You want to always consider the transactional costs of getting paid, meaning things like maybe you are an American company dealing in US dollars, but your partner is a European company dealing in in euros. You know, the currency valuations are going to change pretty much, hour by hour. How are you going to keep track of that? And who's going to pay the transactional cost of that currency exchange or the wire transfer, or the banking fees? And the same thing where you're talking about goods versus services versus intangibles, there might be some tax considerations involved. Right now there is a movement, particularly in some of the Southeast Asian countries, to start implementing a digital tax on digital services. And that's going to impact potentially things like Netflix services or certain kinds of online services. How will that impact the value of the deal that you spent so much time negotiating? I will anticipate mistakes will be made by the business parties while in the process of drafting the contracts. I assume that there are things I don't know about and that there might be a breach. And so you want to also be ready for that and maybe make sure to put in some cushions in case there are mistakes that are made. You never want to walk in knowing that there is a breach already there on day one. Know when to define terms, and here I don't know if you can see it, but I bolded it. And the idea being sometimes there are terms you want to define because it matters. Maybe services, maybe parties, maybe material breach. And you use a capital letter, you'll capitalize it to make it clear that the defined term, but maybe sometimes you don't want to define it because you want a little bit of room to maneuver if there is an issue later on. So you can definitely have a little bit more control over the defined terms. I always try to use plain language whenever possible. I've noticed with some of the bigger tech web privacy policies, they use very, very plain language, which I think is phenomenal. And I try to encourage my team and my business partners to also use very plain language, but you got to still know the difference, the legal difference between the can, shall, may, and must. And that may be impacted by your particular jurisdiction and what the courts in your jurisdiction have defined those to be. There's a school of thought that every term in a contract is negotiable, but in my experience, it is not. And it really depends on the party. It depends on the deal. You may, so here, personal experience, tech companies in California will always insist on California for choice of jurisdiction and choice of law. It's almost always going to be non-negotiable with a California tech company. AccuWeather is based in Pennsylvania, and we have New York offices. And for years we wanted Pennsylvania to be a choice of law, choice of jurisdiction, choice of venue, forum for disputes. And sometimes it doesn't make sense to do that. It's not like we're doing, we're having dispute resolutions happening in person, particularly now during COVID world. And so I do take into consideration things like, well, where are the parties really going to be? Which laws are going to be more favorable to us if I know that? Which courts are going to be considered to be more robust for dealing with dispute resolutions? Is language going to be an issue? And cost factors to hire local counsel wherever the dispute might be. And then just in terms of lingo, I only learned this about maybe 5 years ago, but business people will say things like, do I need to paper the relationship, or whose paper do I use? And that's not lingo that I grew up with, like being a law firm lawyer. And so I know that that's the lingo of the business team. So when they say to you, should we paper this? What they're really saying is, do we need a contract? And it's like, yeah, let's use our paper or use their paper, depending on the complexity of the deal. For kind of like novel deals, like new deals, bespoke deals, I try to do it on my paper and try to draft it myself. Sometimes if it's a little bit more, if it creates a little bit more complexity from their perspective, then maybe I let them do it and be part of the editing portion of that process. Basic structures of contracts in the US, you're gonna have a preamble, which states the parties, the date, the type of agreement. You'll have some recitals like the whereas paragraphs and definitions of terms. And the whereas paragraphs, I like to use to preserve some of that institutional knowledge I was talking about. And it particularly comes in handy if you're doing amendments or you're doing revisions to prior contracts, right? Because if you think about it like mechanically, you have an original agreement that was maybe done 20 years ago. So it's going to be in paper form. Probably there's no PDF, and if there is, it's going to be a copy of a copy of a copy that was eventually scanned. And today in 2020, you want to do an amendment to that. And so you're going to refer back to that agreement, but probably not actually attach that agreement. And so maybe it's nice to have in the whereas clause, whereas clauses, you know, referring back to the existence of this agreement, referring back to the existence of some of the major terms that happened in that agreement, so that in 2020, someone looking at that amendment can say, ah, there was this earlier agreement, let me go try to track that down. And then in 2040, when you're looking to amend the 2020 amendment, now you have a little bit of extra background, and you can sort of have that set of breadcrumbs to go back to. The body of the language is where we're going to find the terms of the agreement. We're going to define the obligations, the prohibitions. This is where the language of the can, the may, the shall, the must is going to be really critical. You'll have a signature page where you've got the signatures, individual names, dates of execution, and then you'll have attachments. Super basic in terms of like what the structure will look like. Again, like I try to keep things as simple as possible. But I also try to make sure that the language included will offer clues to the next generation as to what's in the agreements. Again, I can't stress this enough about the realities of business operations and recognizing that you are drafting an agreement today that probably, if there's a dispute, won't be disputed for a few years. And you know, even if you are still there, you may not remember it off the top of your head, and then you may still have to go back and look at your documents. So you want to ensure that your organization, your clients, your customers have some form of document retention program in place to be able to keep track of this information. Sometimes you can use financial records, you know, making sure that the invoices are there to keep track of what was paid when for what. And then just in the era of electronic files, making sure that they're secure and they're safe and they're accessible as necessary. You know, I was a patent litigator for about 9 years, and it was a very routine fact that the documents we were looking at, they were all created 10, 15, 20 years earlier. And it was always a challenge trying to figure out, you know, who is the best person to talk about these things. And for those of us who litigate in federal court, for example, you know, when there is a corporate witness that's been designated to speak on particular topics, what's known as a 30B6 witness, they may not be the same business person that worked on the deal. And it may not even be someone from the same team. You know, the federal rules of civil procedure only obligate the lawyers to educate that person on the deal. And so you're going to you just want to make sure you've got all the documents in place to be able to speak to that. So for some of the super academics in the world, you know, what about the parole evidence rule, right? And this is the rule that speaks to whether or not extrinsic evidence can be brought in to interpret, you know, so the four corners of the paper document. And you know, the parole evidence rule when I was in law school was definitely the bane of my existence. But it does come up weirdly after the fact, and it comes up in this way. So you have a contract that's been executed and everyone is sort of cool with it. And then someone says about 6 months later, oh wait, no, we didn't really want that service. So I don't really want to, I don't want to do this. And the business people are talking, right? So my business person and the counterpart, they're saying, you know what, you're right. Let's just terminate this deal and let's not really go forward with this. But nobody tells the lawyers, right? And nobody triggers the actual termination provision. And then a few months later, we get an invoice, I don't know, for like $100,000. And everyone's like, what happened here? Like we thought we terminated the service. And so in those situations, I will say that it is worth having those emails and those phone conversations tracked. I mean, we're talking a very short period of time, like, you know, like after these negotiations are done where memories are still fresh. Because even though technically speaking, maybe the contract doesn't permit termination in that way, the business people may recognize that there's more at stake with the business relationship. It might just be way too expensive to dispute it. But it is just something to think about that, you know, academically, the parole evidence rule often will come into play to say, no, you cannot use that extrinsic evidence as a means of interpreting, you know, the clear terms of the contract. But reality, business operations, yeah, save that stuff. It might be helpful. Okay, now we're talking about the mechanics of an agreement. You start at the end to get to the beginning. Whenever I draft a contract, whenever I'm reviewing a contract, the first thing I look at is the termination clause. I always go to see, because it'll give you a lot of information about sort of the complexity of the deal and what you need to do to unwind the relationship. So you look at sort of the basics, right? Like if you have an airline ticket or a ticket to the theater, if you think about whether or not there's a termination clause in there, probably not. because once you've gotten what you paid for, the deal is done. There's nothing to terminate, right? So once a flight's been paid for, travel is completed, all the obligations are over. Or once a theater performance is finished, all obligations end. Or you might have a finite term agreement, a very clear date, right? This agreement shall terminate on December 31, 2021. You might see that in the context of like a rental lease, for example. Or you might see a renewing type of termination. This agreement shall renew for 1-year terms commencing December 31, unless party B informs party A of an intent to terminate the agreement no later than like a month earlier. So what that leads to then is internally as an organization, you need a way to track that. You need to make sure that you've got a system in place to track when you need to notify the other side of when you're going to terminate. Right, so it's great to be able to draft these agreements and draft it in this way, but make sure that your stakeholders, your client, your customer, your business people know that this agreement will terminate, but it's going to auto renew. And if you don't want it to auto renew, make sure it's on someone's calendar as a tickler to remind them. Same with the triggered end. Some of these are self-executing, and some of these are also have some kind of notice provision tied to some kind of an event, right? So you look at like a patent license, for example, the license shall automatically terminate when the patents expire or are deemed invalid by a tribunal of proper jurisdiction, meaning the parties don't have to do anything. Just the minute that those patents are either like they're done, then the license is automatically over. Similarly, party B may terminate this agreement with 5 days written notice to party A, in which case you want to make sure a written notice is defined. Is it by email? Is it a text? Is it by courier mail? So these are the kind of termination agreements that will show up. And while it's great to be able to draft it in a very clean and crisp way, you're going to have to also think about kind of obligations on yourself and your organization if you do it this way. So just, other thoughts for termination clauses, if you're going to have a notice provision built in, make sure that it's going to be reasonable for the business. If you are a business that operates with quarterly invoices, for example, maybe a 30-day termination clause is not enough. Maybe you need 120, or something more than 90 to be able to give your finance team enough time to unwind this. Also, if it's going to require notice in writing in today's era, particularly of the complexities related to a courier delivery or even printing. I can't print at home right now. And so is written notice acceptable in the form of an email, in the form of a Slack message, in the form of an electronically signed document, or does it need to have that wet signature? I like to use explicit dates for termination. So rather than like 1 year from date of execution, because even execution sometimes can be kind of an unclear term, I might recommend using very clearly the month, day, year for clarity. That way, anyone who's looking at the document, whether it's your finance team or your product team, your supply chain manager, they have some clarity in like what the internal obligations are going to look like. And then your particular deal might involve a need for what's, a conditional termination or a trigger termination, where some event, some incident, something will then give rise to the ability to terminate. I'm very, very much obsessed right now with the world as it is, and that COVID world has really changed up a lot of the ways in which I'm looking at some of these terms. And so, is a pandemic necessarily going to be a reason to terminate a deal? Maybe, maybe not. Maybe in certain supply chains, no. In fact, you want to be able to really increase the production line to get the Clorox wipes out to the masses. Or maybe it's for services to an amusement park that will never open this year. Maybe the amusement park will want to suspend those services because like they're literally not making any money this year, and they're just not going to have any money to pay you. So I think it is worth thinking about in the context of like kind of worst case scenarios, the what ifs. This is pretty much a big what if to now take into consideration. And in the event of a premature termination of that agreement, some other things to think about is a refund. Like, is a refund even possible? So if you are in the services industry, for example, and you provide services. So a good example is AccuWeather. We provide weather content to our business partners. And maybe one of them says, I want to terminate the contract. I'm not going to pay you going forward. But what about the stuff they've already paid for? sometimes you need to be clear that no refunds are ever going to be possible, no matter the reason for the termination. That the termination, if there is one, is only going to be a going forward walk away. Or maybe you also want to build in the possibility that rather than a premature termination, the business partners want to talk about the ability to modify the terms of the agreement to be able to add a little bit of extra life for the parties. Now, in terms of once you figured out how the relationship ends, now you can go to the front and talk about how the relationship will begin. You want to talk about the date of the agreement or the date of execution, which can be two different dates. And if every day is important, if every hour is important, this may matter for you. You may want to figure out like who has signatory authority in order to do this. Whether or not the obligations are triggered or self-executing. This comes up a lot in the service situation where they say, okay, the obligations to perform these services will start when we are notified, or it starts when the materials are in place. It starts when this person is onboarded to manage the project. So if you've got terms like that happening, you also want to make sure that it's clear in terms of milestones and dates and expectations. And we're here to make money, so when does payment happen? Is payment happening 30 days from the signing of the agreement? Is it happening 30 days from invoicing? Is it happening 30 days from completion of the service? If you say completion of the service, what's completion? You want to be thinking about those items as well. You know, I really do. I think the payment issue ends up probably being one of the more prickly issues after the deal is signed, because the business people are so excited that everything's been inked. But the finance people then are like, well, now what? Like, do we invoice now? Do we invoice later? Do we pay now? Do we pay later? And so you want to be clear, you know, as much as possible about the amount to be paid. So this is more or less the language in my rental agreement when I was living on Dana Avenue in Albany while I was going to Albany Law School. Lessee shall pay to lessor rent in the amount of $325 US. It was $325 US per month, to be paid by personal check made out to lessor or money order delivered to lessor no later than the 5th day of each month. What did this mean? This meant Jennifer had to write out a check made out to the landlord and deliver it to him every January 5th, February 5th, right? So this is pretty self-explanatory, but it's super clear. It tells you exactly when you have to be paid, how you make the payment, who you pay, you know, who you make the payment to. And, you know, when you can do it like this, it's obviously great for your, you know, the people getting paid because it's so clear. Sometimes you have it triggered. It's triggered based on some kind of a calculation that has to happen after the fact. So I was speaking again about how AccuWeather supplies weather content, weather data. And one of the forms we do it in is in what's called APIs. And they're basically like, you can sort of visual, for those who don't know, it's like telephone calls basically. So you have like little calls like tapping into our system. And we charge it based on a per thousand rate. So we say customers shall pay to provider AccuWeather 10 cents CPM, meaning 10 cents for every 1,000 API calls. And the provider shall invoice the customer on the 5th day of the following month, right? Because you need to have the month of activity. And then we need a few days to calculate it and print out the invoice and send it over. And then payment has to be made no later than the 10th day. And then I like to use, in the interest of clarity, if 1 million API calls are made in May, provider shall send an invoice to customer for $1,000 no later than June 5th, and customer shall deliver payment of $1,000 no later than June 10th. And so you've made it really clear what the different trigger events are, when things are going to happen, and then you give an example to make it really clear. I've done this a few times, and I will say the process of crafting that in the interest of clarity portion oftentimes will generate, even within our own business teams, a discussion of, oh, that's not what I meant. What I actually meant was, and then some other conversation happens, which means what we in legal had been crafting didn't match up to what our own internal business teams were thinking. And so this is a really nice way of clarifying that before things get signed and get more confused later on. And then this is where you want to also think about the transaction costs associated with getting paid and who pays it. Currencies are one thing, currency transaction fees are one thing, banking fees are another, taxation issues. So if you have money leaving one country into another, sometimes those tax regulatory authorities will say, no, we need to hold back X percentage. And then you guys, the parties, figure out like who has to pay whom, for whatever the difference is. And so that may impact the value of the deal as well. What's really awkward, right, is when, as the lawyer, you're asking the business people, hey, like, I see here the expectation is we're going to make $1,000 out of this deal. What's the cost to get to that 1,000? And everyone runs the numbers. You've got the accountants crunching everything, and turns out it costs us $900 to make this deal happen, which means the return on investment for this entire effort is $100. And maybe for the business, it's not worth it. It's not worth the effort. It's not worth all the liabilities that come along with it. So this is a really nice place where, as a lawyer, you can add a little bit of extra value by saying, okay, here's the return on investment, just based strictly on the transaction cost of getting paid. Now, in terms of sort of what I call like the anticipated breaches, and this is different from anticipatory breach, in the contract law sense. This is just strictly like, how can you as a lawyer add value to the business conversation? And the one thing I do is I will say, can we actually accomplish what's required of us? And you sort of want to think about, well, how could the breaches happen? It could happen if they don't get paid, if they don't get an invoice on time, if they don't get the services. Maybe we promise them someone from our development team to be seconded, onto their team, and maybe everyone just forgot to send someone over. And so that could be a breach as well. So you want to kind of think about what are the mechanics of what's expected of us, and can we do it? So I will very frequently go back to my product team, to my finance team, and say, hey, they're asking us to build this out, or they're asking us to pay using this particular payment platform. Can we do that? And they'll say, oh no, we don't do that. We would never do that for security reasons. Well, then we can't sign this agreement the way it is, and I need the business people to go back and renegotiate that portion of it. Same with the defined terms with respect to material breaches, and making sure that we're also not going to too easily walk into it. A material breach should be a really, really big deal, right? And so you want to make sure you do everything you can up front to prevent that from happening. So one of the things you can do as counsel is to then create kind of those soft landings in the event that there is a breach, right? So in the event of a breach of any term of the agreement, the non-breaching party shall immediately notify the breaching party in writing and offer a commercially reasonable alternative and all that, right? The idea being, if I do something wrong, tell me what I did wrong, and tell me as soon as possible. And when you're telling me as soon as possible, also tell me what I can do to fix it. And if I can fix it, I will. And if it costs too much to fix it, promise me that we'll at least talk about the ways in which we can fix it together. And that's basically the kind of thing you want to try to build in, so that you can try to cover for those things you just don't know right now. And then, if you can't cure, if I can't fix it, let's agree to just walk away from everything, with some wind down period. And let's agree that, we don't have to refund each other for anything that's already happened to that date. And that's basically what this kind of a provision is intended to do. Now, if I'm on the side that requires the service, and getting that service is an absolute must, I might then try to redefine what a breach looks like, right? And say, if it's a service-related breach, no. You get 24 hours to cure it. If you don't cure it, you're paying me $1 million, because the services are so critical. So you may have to sort of figure out like how to do that. You can also build in leverage to try to make sure that everyone gets brought back to the table if there is a cure issue. So security deposit, for example, in the context of a rental property rental agreement, that's basically what it is. It's to make sure that there's some leverage on the rentor, the renting party, to follow through with their obligations. And that's another option as well, like basically putting in these extrinsic obligations in order to make sure that everyone stays in their lane and does what they have to do. Just some other terms to pay close attention to. And so what I didn't do was go through like sort of all the different mechanisms that go into a contract. I really wanted to hit kind of high points. And so one of the high points I did want to sort of underscore for this group is this issue of refund. And I think I've probably spoken about it a few times now. I think particularly in COVID world, where people are all looking to figure out how to save a little extra money, figure out like how to renegotiate agreements that they're already a part of, making sure that you build in that if there's triggered payments or milestone events that will then result in payment. So let's speak sort of broadly. I'm getting my home renovated, right? Hypothetically speaking, and I bring in a contractor and I tell the contractor, okay, I'm going to pay you 1/3 when the bathroom is done. I'll pay you 1/3 when the kitchen is done. I will pay you 1/3. I'll pay you the remaining third after we go through the final punch list and make sure everything is done in the entire house, right? And so then the contractor says, fine, you got to pay for the materials up front and whatnot. Okay, so bathroom is done. I pay 1/3. Kitchen never gets completed. I'm very unhappy with what's done. Should I be entitled then to get back money for the entire agreement? Do I get a refund back for what I've already paid? Probably not, because I paid because the bathroom is done and I was presumably happy with it, and that's why I paid it. So you sort of want to think about when there are these triggered payments and milestone events, is the kind of situation where you might want to get a refund. The flip side of it might be, I am a business that relies on getting data, right, from a third party in order to operate. And if I do not get that data, I need to find another source. I've got other obligations that require me to have this data. And therefore, I tell the provider, if you can't give me this data anymore, you've got to give me 30 days notice. 30 days will give me enough time to go find a replacement. So what happens then if that provider just shuts down, disappears, right? And says, sorry, can't give you the information anymore. So now I'm stuck without getting that data. I'm probably in breach of other obligations, and I barely have time to find a replacement. Like, what's my recourse in that situation? Maybe I want to build in, if I don't get the notice, I do get a refund back to X number of days because I need to be made whole. I need to find, maybe more expensive replacement, as a bridge. So I do think it's worth for the lawyers in the room and the business people in the room to spend a little time thinking about if there's a problem with these milestones, like what do you want in terms of, a remedy. So I was talking also about kind of those the very easy breachable obligations, the kind of breaches that you can just walk into without knowing. And I will really highlight data privacy right now is huge. Data privacy is everything happening in the world, and even post-COVID, the regulators around the world are very much fixated on what entities are doing and what organizations are doing. I see a question. I don't know, Joanne, should I stop?
No, I just wanted to give people an opportunity to post any questions in the chat. So I just sent a quick message to make sure that they remembered if they had any questions, we would be happy to answer them, or you would be happy to answer them as we're moving along.
Awesome. Thank you. So from my perspective, data privacy is the world. I believe that there will be a time when potentially, in the American legal system, one of the core first-year classes will be swapped out with data privacy. And we're going to be living in a world where data privacy is no longer a niche practice, but basically something we all have to know and be able to speak about with some level of intellectual rigor. And so, I have been seeing more and more in the agreements I'm working on, where compliance with all laws and regulations is part of the reps and warrants in an agreement, that you are saying, yes, I as an organization follow all the laws and regulations that are legal and that apply to me. And if you're saying that, that then will include things like GDPR, CCPA, the new Brazil regulation, the new, there's a new India regulation coming down the pipeline. And some of these regulations conflict with each other. And if that's the case, you're making a choice, right? To say, yes, I can comply with some, but not all, but then that puts you in breach already of that rep and warrant. And so as somebody who is, oh, I'm gonna pause here. We do have a question.
Thank you, Jennifer. Julie asked earlier in the presentation, you mentioned don't walk into ready-made breaches, and she was wondering, what did you mean by that?
This is one of them. So InfoSec, the information security systems that you might have within your own organization, that's an area that's very ripe for breach, in that you'll be working with a third party who says, hey, Jennifer, really excited to work with AccuWeather. Could you fill out this vendor questionnaire that we have? Standard, we ask every single one of our vendors to fill this out. Cool. So I take the vendor questionnaire, I look through it, and it says, you, vendor, agree that you comply with all of these InfoSec policies and requirements and obligations. And me as the lawyer, like, I have no idea what the language even is, right? So I send it over to my IT guy and I say, hey guy, like, can you take a look at this questionnaire and, let me know if everything's cool. And they come back and say, we don't adhere to these policies. We're just not certified in these particular areas. We're just not. It's not a good or a bad thing. We're just not. We're not out of compliance with any laws or regulations. We just opted to not get certified in these particular policies. What do I do? As counsel, I go back to the business person and say, you're gonna have to talk to your business counterpart and say, we can't sign this questionnaire. Because if we sign this questionnaire, right, then we are saying that we are compliant with all of these requirements. And I know we're not. So we've already breached the agreement at that point. And so that's sort of what I mean by a ready-made breach, where it's really not because you didn't consider something. It's because there are these other external or tangential considerations that that you really have no control over. And so, having that conversation with your business teams and making sure that all parts of the company are on board, that's going to be that's going to be sort of be an everyday task. It's not a one-time thing, but it's really just understanding how your operations work. Another way this comes up might be our company no longer will pay via. We only have certain mechanisms for payment. We will pay by ACH, we'll pay by wire, we'll pay by check. That's pretty much it. And so if you are a company that wants to be paid by PayPal, we won't do it. And so if in the agreement it says you must pay by PayPal, can't do it. And so I don't want to sign that agreement knowing I'm going to be in breach. It's not a big deal breach, right? We can probably figure out a different way to get them paid after we've signed the agreement. But I know even before we signed the agreement that this is going to be a problem. So that's sort of what I mean by walking into certain breachable obligations. Exclusivity is another big one that I very strongly urge all lawyers and business people to think about. Exclusivity sounds awesome, right? It sounds like you and I have this exclusive thing happening together. And the problem, and people will really value exclusive deals, exclusive relationships, because it kind of sounds cool too. But if you don't track it internally, if you don't have a mechanism for tracking that, how will the next deal maker know that this is in place? How will the next business person know that they can't give away what you've already exclusively given away to another party? And so whenever I see exclusivity in a deal, all of my red flags go off. I make sure that we've got all the approvals in place. I make sure that at the highest levels, people know that we're entering into an exclusive deal. Doesn't matter the dollar value, right? And in fact, the smaller the dollar value, that just means you're giving away the exclusivity for not much money. It's a big red flag for me. Is there another question, Joanne? No, okay.
Nope, Jennifer, we're good right now. We do have something.
Yep.
Let me just read this. As lawyers, we have certain ethical responsibilities with respect to technological competence and protecting client data, and part of compliance probably includes due diligence on third-party vendors. So arguably, law offices who make agreements with third parties should be auditing their policies to make sure they are able to protect client information. So law firms entering into deals really need to examine provisions like you talked about closely. Couldn't an automatic breach like the one you described have serious consequences in this respect and cause liability in different ways than simply under the agreement?
1000% right. Exactly. And so the breach portion of it obviously is a small part, but yeah, you might be out of compliance with your own data privacy regulator in your jurisdiction. You might be out of compliance with some other organization that is a watchdog for your particular industry. 1000% right. And so making sure that you also have those discussions with your IT group, with whichever business units oversee those functions, yeah, you have to have those conversations. Now, I am speaking more in terms of just the easy breach, right? Like it's a very complicated conversation to have with IT about their policies and what the requirements are, and that's a very big conversation to have. But if I can just go to the business person and say, we're not going to be able to adhere to this, that's a very easy way to try to get them then to go back to the table and figure out, like, is this going to be something that's worth the effort and the resources to get there? Because some of these conditions are going to be absolutely required for the deal. And maybe as an organization, you're not equipped to implement that yet. That's okay too. This is not, there's no value judgment here. This is just kind of reality check of what's going on. In terms of jurisdiction, choice of law, choice of forum, like all the good stuff that speaks to who gets to adjudicate the disputes that happen here. You know, I think that if you are fully, you know, if you have full knowledge that a particular jurisdiction is going to be favorable to you with respect to this deal, yeah, go for it. You know, try to press on that as a negotiating tactic. But you know, I mean, the lawyers in the room, you know, we know like how fluid the law is, how everything depends, right? Any question you ask to a lawyer, it's going to be probably start with it depends, because it really does depend. And so what then are some of the metrics that you can think about in trying to control for this? And so for some of the standard deals where I know that the likelihood of a dispute is small, big picture wise, right? Like once the services are given, we get paid. There probably isn't going to be a need for dispute unless maybe there's like an IP breach, or maybe there's a confidentiality breach, something like that. And so if that's the case, then, you know, I want a court that's going to have, that's going to be known to be respectful of IP, be respectful of disputes between parties, different parties. If it's going to be in a different country, I want to have some confidence that an American company will be treated fairly in that jurisdiction. Language could be an issue. Obviously, I would prefer to be in an English-speaking jurisdiction, because then I don't need to pay for an interpreter. I don't have to pay for certified translation of documents, which can be very expensive. Maybe distance is an issue if I believe that a dispute will be best handled in person, or if there's a need for local counsel, right? So I am admitted to practice in Pennsylvania, New York. I could probably get, you know, I could probably do, you know, the in-person appearances on my own. I don't have to pay someone locally to show up. In California, I'm gonna have to pay someone to show up out there. If it's in the UK, Singapore, Hong Kong, I'm gonna have to pay someone to be out there. And so I would say, you know, if it's important for your organization to have a particular jurisdiction as the choice, then that's a conversation to have internally. And you know, if you sort of weigh all the possible ways in which a dispute could happen and then the chances of it, I think it's, you can use some other objective metrics to decide whether or not this is something, this is the hill to die on. Like I said, like when I deal with California tech companies, California is going to be choice of law all the way. They will walk away from the deal, has been my experience. So I'm not going to press the point, because I know how important it is for the business people to get the deal done. I always look out for mandatory arbitration, because for those litigators in the room, you know, arbitration is, it really is a die roll. You know, depending on which arbitration system you operate under, this might be it. It's a one-shot deal. There's no appeal. There's no going to court. There's no going anywhere else after this. Some arbitration systems, it's actually truly arbiter's choice. They don't even have to really abide by, you know, the options offered by the parties. They could just do whatever they want. And so I think mandatory arbitration ends up being sort of a power leverage, where the more powerful company will insist on it over kind of the less powerful party in the deal. And so I would just be sort of aware of that, and be thoughtful about whether or not it matters or doesn't matter for your deal. In the era of social media, in the era of how quickly information is disseminated across the internet, I would also be mindful about clauses that speak to or even don't speak to press releases, publicity, social media, and trademark usage. You know, if it's a really, really big deal, maybe you want to be a part of the press release that goes out. And so you want to put something in there about how the parties shall work together to formulate a mutual press release, you know, and then some other conditions for the individual press releases. Maybe you want to have some control over the social media. Maybe you want the party you're contracting with to push out, you know, X number of, you know, tweets every day, because that's part of the value you're getting in the deal. So you want to make that crystal clear. I've literally had deals where I would call out, you know, the other party had to have 3 tweets a day, spaced out every 4 hours, based on the Eastern Standard Time Zone, and it must contain a minimum of 20 words. Like, it's some crazy formulation, because we wanted, I think it was an influencer, we wanted to make sure that we got the exact brand value for that deal. And same with publicity, because publicity rights can vary from jurisdiction to jurisdiction. You may want to be a little more thoughtful about, like if the president of the company wants to be like in the images and the commercials and, the media and the marketing that goes out, you want to make sure that you've got all those rights locked down, because in some states you might not be able to, you may have some issues in some states. Assignments in the clause, in the contract will be something you want to look at, particularly if you're dealing with a customer that is very heavily courted by a competitor. And what I mean is, let's say, for example, that your customer is bought by your competitor. Do you want the ability to know that that's about to happen? How much advance notice do you want to have? And do you want to have the ability to continue with the contract or terminate immediately? Because in theory, maybe you don't want your competitor to have any access to your information or your services. Severability is another clause that's quite important across jurisdictions. What it allows is that if some part of the agreement is considered to be illegal or invalid, you can just strike those clauses and everything else in the agreement will still be valid. And this might be important, for example, like in a confidentiality agreement. So maybe a portion of that agreement is considered to be too overreaching or overbearing, but you still want the parties to be held to the confidentiality agreement, for the 3-year term or whatever it is. My understanding is, like in certain jurisdictions like Australia, for example, you must have severability, the ability to sever. And I'm not sure exactly how that works, but in some jurisdictions, it's going to be a requirement. Let's see.
Jennifer, we do have a question in the chat. Okay. Lenny would like to know what kind of key issues triggers a need to seek opinion of outside counsel in the context of the contract drafting / negotiation process.
So, hey, Lenny and I went to high school together. So it's so great here and throwing out this question to me. So from my experience, I will go to outside counsel if we are in a heavily regulated industry. So it's not necessarily the term itself, it's it's sort of the nature of the deal. So if it's a heavily regulated industry, so if it involves, let's say we have a cable network, and so some of our network deals are super, they have industry nuances that I could read everything out there and I would probably still not pick up because I'm not in that industry. So that would be an area where I would pull in outside counsel. I might pull in outside counsel for local deals in jurisdictions where I'm just not comfortable with kind of nuances of the language and the law. So on occasion, like I have, counsel out in Ireland that I might touch base with, counsel out in India. I have someone in China that we work with regularly because of our relationships out there. So that might be an instance where I know, and just for context, like I read a lot of stuff that happens around the world in the legal space, right? Because I feel like the stuff that makes the news, like will be the kind of crazy stuff that happens. And so I read about that in order to be able to get some insights into whether or not something's going to be an issue. So now that I know that there's this digital tax, so it's basically a digital VAT coming down the pipeline in Indonesia, I might want to then reach out to someone in Indonesia, to the extent that our business is growing out there. So those are the kind of issues where I might then bring in outside counsel to help me with the drafting and the negotiation process. So we've got just a few more minutes, and I just want to touch on the COVID world. And what COVID has done in terms of sort of the negotiation process and sort of the look back on agreements that we have. So, we've gotten a lot of asks from our customers to either terminate agreements or to pause them, particularly when it comes to providing data, because they're just not doing business anymore. And as a business, we have been trying to work with customers to make sure that we maintain that relationship with them. So maybe we won't terminate, this summer, we'll just pause the services and say, in exchange for the pause, will you sign for another 3 years with us? And that way, we feel some confidence that, they're going to be with us for the long haul. They feel confidence that we believe in them as an organization and as a customer. And so we try to do things like that to try to help make sure that the business relationships have been shored up. But, there's some other complicating factors, like force majeure is a big one right now. And that's going to be what typically is, sort of seen as the act of God, clause. Like if there's an act of God, right, some extraordinary event or circumstance beyond control, beyond the control of the parties that prevent us from fulfilling the obligations. And the problem with force majeure is sometimes the way act of God is defined might exclude a pandemic, right? And that's going to be the big challenge right now going forward, particularly with property leases and other kinds of service arrangements. And so, what's going to happen now? Everyone's going to try to stick in pandemic, right, into force majeure if it helps you. And the other side's going to be like, no, we didn't have it before. We're not doing it now because it helps them. So I think we're going to have to just kind of be a little bit more mindful about this being an issue going forward. I think if you as a lawyer puts in pandemic, in the force majeure definition, I think you're doing your diligence as counsel to your client. And if the other side says no, I think you're going to have to negotiate that. Impossibility of performance is another clause that I think will be also heavily litigated, that there's a change of circumstance that's going to prevent the obligation from being fulfilled. In the context of New York City real estate, for example, like, did the governors in New York State, did the governor's order prohibiting people from being out in the streets, during the period of, I think it was like March 16th till till June 22nd, whatever it was, is that going to be considered a change of circumstance that then would have prevented certain obligations from being fulfilled? So I think that's going to be an interesting thing to watch out for. Pandemic event and related, things like what do you do if you lose your job, if you lose access to income, if you lose revenue? Can you use the pandemic event as an explicit trigger for termination, expedited payment, or additional obligations? And no, maybe. Like I think that's definitely worth exploring. So maybe if your apartment lease is due for renewal, maybe you see if your landlord would be willing to stick in there if you lose your job because of a pandemic related economic downturn, that you'll be able to either get a reduced rent, right away, or get out of the lease altogether. And I am fixated right now on the Jenner & Block situation out in Chicago. Jenner & Block is a big American law firm, and they have this huge office space in Chicago. And basically they stopped paying the rent, saying that their lease actually included a negotiated provision for rent abatement in the event of a global pandemic. And the landlord is like, no, and you owe us money. So this is going to be an interesting one to watch, to see how the issue of a pandemic, the issue of usability of space, and clauses that discuss rent abatement in this situation, how that sort of shakes out in the courts. And I think that's it for me.
Jennifer, we actually do have another question.
Yes.
Juan has asked, do you think COVID-19 will trigger an increase in the number of disputes?
First of all, hey Juan, he's a classmate of mine.
I know he is. Hi, Juan.
COVID-19 will unquestionably increase the number of disputes. I mean, already we're hearing about both insurance claims, insurance rejections being disputed. We're hearing about leases, property leases being disputed. This has already been happening. I think it started happening probably in March or April, where people were preemptively trying to test to see what's happening. I mean, in the US, right? Like we're talking about how to offer additional economic relief. And part of that is trying to build into the legislation, like things about like how to avoid liability, like how to mitigate liability for, let's say, employers, or how to deal with the insurance industry. So we're gonna see, like, for example, COVID related issues related to employment conditions. What if your employer requires you to go into work because that's in your contract that you must be, at work, on the premises X number of days, and then you contract COVID. Is there a claim against your employer because they required you to be there, or is there some other mechanism for resolving that? So yes, the answer to that is a big yes. And I think some areas, some legal practices will see a decline in work, but I do think like labor and employment and litigation, insurance law, I think those areas will definitely see a big burst of activity.
Thank you very much. And by the way, sorry for getting late to the meeting. I sort of miscalculated the time difference, and I'm sorry for that. Thank you, Jennifer.
He's in Barcelona right now, so thank you. And that's all I have. So here's my contact information. Please feel free to email me if you have questions. Definitely find me on LinkedIn, link in with me, connect with me, send me messages. You know, I'm open to questions.
Thank you so much, Jennifer. This was great. One of the question is the PDF available for the
Yeah,
presentation?
Joanne, I sent you the
I
you can circulate that. That's fine.
absolutely great. We have a list of attendees and we'll circulate the PowerPoint after the presentation.
Awesome. Thank you.
Jennifer, thank you for everything. It was a pleasure to see you, and we really appreciate you being part of the Women's Leadership Initiative.
Thank you so much. It was really great to see everyone.
Thank
Thank
you.
you.